Hi and welcome. By the time we're done, you'll know how to be prepared for and protected from life's eventualities, including how to avoid probate and protect family. If you want to avoid probate, protect children and spouse, stop family fights, be prepared for life's eventualities, and feel the peace of mind that comes from being ready, then this may well be the most important presentation you've ever seen. I'm going to teach you secrets to a successful estate plan. And I can make a certain bet that very few people know all of these, but everyone should know each and every one of them. Today, you're going to discover estate planning is much more than a will, how your plan can fail with dire consequences, why you want to plan now, and how to create a successful plan. If you don't plan, your family will have to go to court and face the judge. Your family can literally tear itself apart arguing over your decisions and stuff. You leave yourself and your family exposed to probate, financial predators, opportunists, scam artists, creditors, publicity, loss of privacy, and much more. Do you want your friends and neighbors to be able to see your family's affairs and know exactly how much you're worth? Not to mention, financial predators, opportunists, and scam artists look for this stuff every day. I had a pretty normal life for a boy growing up on a ranch in northeastern Oklahoma. I spent my days going to school and my mornings, afternoons, and nights working on the family ranch. At an early age, I learned the importance of hard work. My family raised me with strong values: perseverance, honesty, integrity, and service. I was able to attend Oklahoma State University, majoring in business administration and computer science. After I graduated, I spent the next 20 years working as a computer professional and consultant. In February of 2010, my father passed away of a sudden heart attack. Because of this, Mom and I had to take the family farm through probate for the third time since 1975. This time, it only took 8 to 10 months, fairly short by probate standards. Later in 2010, I experienced some heart problems. While lying in the hospital and reflecting on my future, I decided to take my life and career in a new direction. Because of the experience and stress of going through probate court, I decided I wanted to help families navigate their own probate issues, and through proper planning, guide others in avoiding this stress altogether. Although not many people go to law school with the goal of becoming an estate planner, that's exactly what I did. I went to the University of Arkansas Law School, graduated, passed the bar, and became an attorney. I opened a DeWitt Law Firm, and I limit my practice to the areas of estate planning and probate. Growing up on a farm, it was understood that during the good times, you prepare for the not-so-good times. With proper estate planning, your family shouldn't have to go through probate. Nobody should have to add the extra strain to an already emotional time. The best part of being an estate planner, what motivates me every day, are the families I get to work with. Meeting you, hearing your stories, and counseling on creating practical and effective plans for your future is a gratifying experience. My education, coupled with valuable life experience, gives me a unique perspective and allows me to bring estate planning solutions to your family in a way that goes beyond the traditional lawyer-client relationship. I don't provide canned, one-size-fits-all plans. I firmly believe that no family should have to go through the struggles of probate. Nobody should ever have to go to court to have their right to make their own decisions ripped away and given to somebody of the court's choosing. Everybody has the right to pick who will make decisions for them if they can't because of any reason. Today, you'll discover estate planning is much more than a will, how your plan can fail with dire consequences, why you want to plan now, and how to create a successful plan. If estate planning is more than a will, then what is it all about? We'll discuss why a will isn't all you need in just a bit. However, before we go any further, we need a common definition of what an estate is and what estate planning is. Simply put, your estate is everything you own. It is your real estate, possessions, money, accounts, investments, and more. Your estate is not a big fancy house, well, unless of course you live in a big fancy house. Estate planning is about much more than writing a will. There are two parts to estate planning. The first part is what you typically think of. The first part is distribution of your final estate. This is the realm of wills and trusts. The second part is about protecting your assets, money, belongings, and possessions during your lifetime. It is about providing for your care if you can't make decisions because of loss of mental capacity. This is done through a combination of powers of attorney, healthcare directives, and trusts. You designate, without court intervention, who will manage your affairs and property during incapacity. You ease the burden on your family in hard times. You minimize delays, taxes, costs, fees, and more. Planning works great when done right and fails horribly when done incorrectly. I'm going to go through a list of the top reasons plans fail, then dive deeper into each one. Putting your children on the deeds. Putting your children on the accounts. Relying on joint tenancy to pass property, and not planning at all. Now, adding your children to the deed to avoid probate sounds like a great idea, but doing so is highly dangerous. When you do this, you have made a gift to them. You have given them partial ownership. One person controls the fate of everybody else on the deed. For example, if they are in a car accident, get sued, and lose, then that property can be sold to pay for their lawsuit. If they get in tax or credit problems, your property can be used to pay. Adding your children to the accounts to help pay bills and avoid probate sounds like a great idea too. Again, doing so is highly dangerous. You have made a gift to them. You have given them partial ownership of the account. One person controls the fate of everybody else on the account for the same reasons we just discussed with deeds. And we've already discussed the problems that can happen when you put your children on a deed or account. But there's one more you probably haven't thought of. What if they pass before you? What if you and your spouse pass together and you are the joint owners? In that case, joint tenancy has done nothing to avoid probate. And the best way to make sure your estate plan fails is to not do anything. If you don't create your plan, the state has written one for you. It's generic. It probably doesn't do what you want. It involves courts and judges, and it is expensive. Here are 10 excuses people use to not plan. They have excuses to delay their planning. I don't have enough. I don't see the need to plan. I want my heirs and family to fight. I don't want to pay for planning. I don't want to make these decisions. I don't want my child to get anything. I won't be here. Why should I care? I have an old plan. It should be good enough. I'm going to spend it all, and I don't know where to start. Without a solid plan, the possibility of family fighting over small things multiplies. Often, it is not the more valuable things that cause the problems, but the little stuff with sentimental value. Often, small estates involve more fighting between the siblings because there is less to go around. And people don't think about the lifetime benefits of a plan. They are fixated on the distribution of their estate. Planning does. Planning is about protecting you, too. If you don't see the need, stick around and I'll explain why you need a plan. Even if you don't have much property, you need to protect yourself. Without a plan, the courts get to decide who will take care of you and your affairs if you aren't able. If you want to see your heirs and family fight, then don't write a plan. The fights can be large and expensive, not to mention they can tear families apart. A plan is an investment, not a cost. Planning now is cheaper than reacting later. So, for example, if you had about a $100,000 estate, the cost of probate will be around $6,460. If you needed a guardianship to manage your lifetime affairs, the additional cost would be $2,500. That comes to a total of $8,960 spent out of pocket. And that doesn't include the cost of losing your and your family's privacy. This may be the number one reason people put off planning. Make the best decisions you can now, and if you need to change them later, then change them later. Life constantly changes, and you need to adapt. If you want to leave a child out, you must write your own plan. The default plan from the state splits everything evenly between all your biological and adopted children. Stepchildren are excluded. If you want your family to have the extra expense and hassle of probate, then don't write a plan. If you want your family to avoid probate, save money, and prevent hassles, then you should write a plan. Spending it all is a great plan, except for the fact that accidents and major medical incidents strike without warning. If you get hit by a bus tomorrow, you have left an estate that will need to be handled, and since you didn't plan, you don't get a say. By watching this, you have started. The best place to start would be to come in for a conversation. I'll tell you how to do that in just a few minutes. Let's talk about Sonny Bono. Sonny Bono, the singer, songwriter, restaurateur, and former congressman, died in a tragic ski accident in 1998 at the age of 62. His net worth was just under $2 million at the time of his death, yet Bono did not have a will. Apparently he meant to have one drawn up, but simply never got around to it. Bono's fourth wife and surviving spouse, former Representative Mary Bono, spent years battling to be the executor of his estate. She also faced lawsuits filed by anyone and everyone who wanted a piece of the pie, some who you won't believe. A secret love child made his own claim on Sonny's estate. Then 35-year-old Sean came forward claiming to be Bono's illegitimate son. Cher, Sonny's second wife, sued for a share of his estate, seeking $1.6 million in unpaid alimony. After years of fighting, Bono's estate was eventually divided between his surviving spouse and his two children, Chastity and Christy. I want to run quickly through this list, then expand on each one. Probate, guardianship, incapacity, loss of control, loss of privacy, worry, financial predators. You protect your children and spouse by planning. You shield them from publicity and the hassles of court. If something were to happen to you, your spouse and children may be facing long court proceedings to take care of you in guardianship or settle your estate in probate. I could spend hours, if not days, talking about probate. Probate is a court-supervised process controlled by state law that transfers your final estate to your heirs and beneficiaries. Unlike what many people think, if you have just a will, probate is required. Fortunately, if you have a plan, you do get to say who gets what and how much. Court supervision can be minimized. Unfortunately, most form wills I've seen don't give a very wide authority or depend on state law to grant authority to do things. An improperly written will can leave property out, and that property will be fully subject to the state's plan for probate. If you don't have a will or trust, state law completely controls the process and who gets what and how much, not you. State law requires that your estate be managed by the court until it is settled. Here's an overview of probate. Lawyers will be involved and charge a lot of money. Probate is public. Do you want your affairs in the public eye? Do you want the public to know what you have and who gets how much? It creates hassles for those you leave behind. Takes 8 months or longer. Often, assets are frozen until the end. Without a will, the state is in complete control and decides who gets what and how much. If you become incapable of managing your own affairs, nobody else has the authority to manage them for you. Hopefully, somebody steps up and goes to court, gets a guardianship, then takes over managing your affairs and business. And you better hope that it was somebody you wanted in charge, not your son that is just after your money. Worse, it could be Adult Protective Services. Also, guardians can't make all the decisions. From time to time, they have to go back to the judge and ask for permission to do things. Finally, a guardian must file an annual accounting and inventory. These become part of the public record. Incapacity often strikes without warning. Dementia creeps up. Accidents and major medical incidents happen without warning and leave people unable to manage their affairs. If you don't plan, then you're giving control to the state. The state will decide who controls your life with a guardianship, and afterwards they have a plan for distributing your final estate. As we talked about before, the state's plan creates public records that anybody can access over the internet. Financial predators, opportunists, and scam artists scour the internet every day looking for the public records they can take advantage of. I personally know this because every time I open a probate, I get 2 or 3 offers from people that can find the heirs or want to sell the house. Because your affairs are exposed to the public if you don't have a plan, financial predators, scam artists, and opportunity seekers take advantage of your family. With a plan, you can stop worrying about it and feel peace of mind. Paul Walker, the actor, left this world on November 30th, 2013 in a car accident. He was 40 years old, and he left a 15-year-old daughter behind. He did have a trust and a will. Unfortunately, he made the choice not to put everything in the trust. So, his will had to be probated. Because of this, we know that he left at least $25 million in assets behind. Eventually, the funds were put into the trust because of the terms of the will, but the point is, he made several mistakes. He didn't fund his trust and depended on his will. Probate is public. This exposed his daughter to public scrutiny and financial predators. I can't begin to imagine the number of calls from financial advisors, people with offers, and more that she received. He created his will when he was 28. However, he never updated it. He didn't take advantage of any estate tax planning, and his estate was subject to high taxes. Now let's look at how you can create a successful plan for you and your family. Your successful plan will be the road to peace of mind when it comes to protecting family in the best way you can. The best way is to look at each item in a plan and what it does for you and your family. Your durable power of attorney allows you to pick a trusted family member or friend, your agent, to take care of managing your money and other property if you become mentally incompetent. That is, you are unable to make rational and informed decisions or become incapable of resisting outside influence. Without a durable power of attorney, bank and investment accounts held in your name will become inaccessible. IRA distributions can't be requested. Bills can't get paid, tax returns won't be filed, and real estate can't be bought or sold. Instead, a loved one may be forced into court to get a guardianship. Your durable power of attorney can provide authority to handle your affairs without the court's involvement. A healthcare power of attorney is the equivalent of a durable power of attorney only for your healthcare. You pick people you know, love, and trust to help you make healthcare decisions for you. You keep your right to manage your medical affairs by writing down your choices now. You decide now what you want and don't want done. HIPAA is a federal law that limits access to your healthcare information. It limits who can request your medical records, talk to doctors, talk to nurses, and even see if you are a patient in a hospital. It defines your medical records as protected healthcare information. That information can't be shared except with insurance companies and possibly other doctors. In order to let your family, even your spouse, talk to doctors, see your medical records, and more, you need to give them permission. A living will is a healthcare document for use in your last moments if there's no chance and you can't communicate your wishes. Remember, a last will and testament is how you want your property managed and distributed after you're gone. Your living will, also known as an advanced healthcare directive, personal directive, medical directive, or advanced decision, is a legal document in which a person specifies what actions should be taken for their health if they're no longer able. This document supplements your healthcare power of attorney and is mainly used if you're expected to pass an hours and nobody is there to make decisions for you. You get to choose which document takes precedence. Do your instructions in the living will take precedence over your healthcare power of attorney or vice versa? Last will and testament requires probate. Probate is public. Your will becomes part of the public record. Your will is like a letter to the court telling the court how you want your property distributed and who you want in charge of the distribution. Somebody must make sure that the will is proved to the court, that is, this is the original will and it was signed correctly by you, that all of your property is collected and appraised, and that all your bills and taxes are paid before your property can be distributed to your heirs and beneficiaries. A judge must validate the will and appoint the person in charge of the estate. Only then is the will valid and in effect. Until then, it's just a piece of paper with no legal power. Trust avoid probate. Trust protect family. Trusts are private. I like to think of a trust like a treasure chest. On top of the lid is written a set of rules as to who can get into the chest and what's to be done with the stuff in the chest. During your lifetime, you put stuff, your property, into the chest and you can take the stuff out. Everything in the chest is for you and your spouse's benefit. You maintain control over everything in it. You have the key to the lock and therefore you control the trust property. However, after you pass, the lid is shut and locked. Now, only the person you named, the trustee, can access what is in the chest and must follow the rules written on the lid. Only your trustee has the key to the lock. Since technically you didn't own the property, there is nothing to go to probate. Instead, your property and assets are quickly distributed to your heirs without all the red tape and bureaucracy. Your successor trustee doesn't have to get the approval of the courts. Technically, a trust is a contract between two people for the benefit of others. The first party, often called the settlor or grantor, settles or grants onto the second party, the trustee, property for the benefit of the third party, the beneficiary. The trust document formalizes the relationships and sets forth the rules for managing the property and money in the trust. This is all the detail I'm going to cover on the legal definition. If you want to know more, give me a call and I'll happily discuss it with you. The Florida case of Aldrich v. Basile illustrates exactly why you don't want to fill out your own forms. Anna Aldrich wrote her will on an easy legal form. On that form, she left a list of property to go to her sister Mary Eaton. She also wrote, "If Mary dies before I do, I leave all listed to James Aldrich." Containing no other distributive provisions, the will was duly signed and witnessed. The will did not contain a clause to take care of the rest and residue of the estate. It made specific gifts of specific property only. This is a mistake that is easy to make. 3 years later, Miss Eaton died before Anne, becoming her benefactor instead of her beneficiary. Miss Eaton left cash and land to Miss Aldrich, who deposited the cash she inherited from Miss Eaton in an account she opened just for the purpose. On October 9, 2009, Ann Aldrich passed, never having revised her will to dispose of the inheritance she received from her sister. After inheriting from her sister, she did leave a handwritten note, possibly an attempt at a codicil to her will. However, this note was declared invalid due to improper signature and witnesses. Ultimately, her nieces inherited a portion of the property Ann inherited from her sister. At this point, you might be wondering, what is my next step for creating a successful plan so I don't have to worry about life's eventualities and will feel peace of mind? So far, you've discovered estate planning is much more than a will. How your plan can fail with dire consequences. Why you want to plan now? How to create a successful plan. I want you to get this one thing. You create a successful estate plan to avoid probate, protect your children, protect your spouse, protect yourself, stop family fighting, and feel the peace of mind that comes from being prepared for life's eventualities. How do I get started? You have two choices. The first is trial and error. The second is to use my proven planning system. Introducing the Top Secrets Planning System. How to take care of family, including yourself, loved ones, and your money without breaking the bank, probate, and family fights. When you use this system, you'll know what you need to feel peace of mind you've been seeking, avoid probate, and protect your loved ones. You don't have to figure out everything. We'll help you with that. You don't need all the answers. We'll help you with that. You don't even have to have everything organized. We'll help you with that too. When you're done, you'll have your estate organized on paper, have all those decisions made, and have a plan that avoids probate, protects family, stops family fights, and lets you feel the peace of mind that only comes with a plan. Your first step is to come in for a conversation. We'll discuss your goals and desires for all aspects of estate planning, not just wills and/or trust. We promise when you're done with this conversation, you'll know how to be prepared and protected from life's eventualities, including avoiding probate and protecting family. We aren't going to try to pressure you into buying something you don't need. If you decide after discussing your unique situation and hearing my recommendations not to go forward, we aren't going to apply any high-pressure sales techniques. However, if you do decide to go forward, I'll put together the best plan I can to meet your needs and goals. When you come in for your conversation, this is what you'll get. We'll have a full 60-minute in-depth conversation about your unique family, finances, and goals. You'll get to tap my professional expertise and 50 years of life experience so you know you're doing the best you can for you and your family. Of course, you may be wondering how much I charge for this conversation. An hour of my time is worth $250, and my expertise is worth at least $500. However, I don't charge for the initial conversation because I believe you should have a chance to meet me and decide you are comfortable before we move forward. But you'll get $750 or more in value just for coming in. When you leave the meeting, you'll leave with an advance medical directive, also known as a living will. We want to make sure that if anything happens, you get a voice in your treatment. And if you don't already have a copy of the book, 10 Top Secrets of Successful Estate Planning, you'll go home with a printed copy. You don't often hear an attorney guarantee anything, but I do. I will do the absolutely best job I can. You get my 100% best effort. I feel you won't get better estate planning service anywhere. I will be on time. Your time is valuable. If I am more than 15 minutes late for your appointment, I will give you $50. For estate planning work, there's a flat fee quoted up front. You'll know ahead of time exactly how much your plan will cost. No matter how much time is put into creating your plan, the price will remain the same. No high-pressure sales. I don't believe in trying to pressure you into buying. I'll lay out the facts and let you decide. And finally, I guarantee if you don't do something now, you're going to get the same results and continue to worry and fret. These conversations are necessarily limited by time. We schedule them on a first-come, first-served basis. To claim yours, you can call 479-717-6300 or go to planwithgary.com. We'll do over-the-phone and in-person appointments, whichever you prefer. During your 60-minute conversation, you get access to my professional expertise and life experience. You leave with a living will ready to be completed. You'll get a copy of the book, 10 Top Secrets of Successful Estate Planning. These conversations are necessarily limited by time. We schedule them on a first-come, first-served basis. To get yours, call 479-717-6300 or go to planwithgary.com. We do over the phone and in-person appointments, whichever you prefer. Remember, you will create a successful estate plan to avoid probate, protect your children and spouse, stop family fighting, and feel the peace of mind that comes from being prepared. These conversations are on a limited basis. We schedule them first come, first served. To claim yours, call 479-717-6300 or go to planwithgary.com. We can have this conversation over the phone or in person, whichever you prefer.